to see you all again. Happy Friday. Welcome to our weekly privacy chat, which has been getting a really thoughtful, interesting audience of data protection geeks and those who love them from around the world. I'm joined today by FPF Global Privacy Lead Gabriela Zanfir-Fortuna, who many of you know, and working on Friday. It's vacation day in our Tel Aviv office, and I think in Dubai as well. Is Friday a work day? No, it's not. But Lori Baker works 24/7, protecting, dealing with data protection challenges, and so she joins us from the DIFC Commissioner's Office. I'm going to let her tell those who don't know what her data protection agency is a quick bite about what that is. But I know the reason many of you are excited to be here is that this is a dramatic week when it comes to international data flows. We understand from Facebook's SEC filings where they clearly have to disclose. You don't get to lie or say political things in your SEC filings. You got to tell the investing world what risks you believe you face, and they set out therefore that they expect, as do others, a block, a maybe deletion of data flows due to the follow-on from the Schrems decision, the complaints in Ireland, and the EDPB mandate to the Irish DPC that Facebook indeed cannot transfer data to the US. Lots of people are like, well, of course, Facebook. Lawyers who are interested in data protection, I think, look at these things and say, okay, well, why does that apply to me? Does that apply to all my clients? Does that apply to my company? No, say some of my European friends, oh, it's just about Facebook. Yes, I'm like, does this decision actually mean that just about every company or university or any organization moving data at large scale, as so many do, not for profits, governments cannot, if one accepted this as a legal principle in the US, when the FTC brings in enforcement, we say, oh, this is de facto case law for everyone else in similar situations. This is where the regulator would bring a complaint. So I imagine companies and countries around the world who similarly do not have perhaps an adequacy arrangement with the EU are planning on a halt to the global economy. Well, that's not happening. Maybe there's more nuance to this. Okay, we'll talk about that. The other thing in the news today is that the US is in the middle of looking at some of the European countries, Hungary, Poland, some others, where perhaps rule of law or data protection and surveillance regimes may be worth a careful discussion, because the proposed agreement between the US and Europe has a sort of mutual recognition. Now, we know this will happen. We don't know whether the court will pass it, but we are in the midst of a bit of a time of drama. So no better time to talk to Lori Baker, who I always enjoy and appreciate her office's thoughtful and leading work. But what really caught my eye was maybe a year ago, where she and the team at the DIFC did an assessment of countries around the world, because if you're serious about your requirements for adequacy, your requirements for data transfers, what are we expecting? Small startups and everybody to somehow commission their own legal study, which is different than everyone else's legal study about which countries might be higher risk, which might be not. It's silly, but yet not too many regulators, I don't know, maybe no one else, publicly had sort of the fortitude to say, well, let's commission some experts, let's take input, and let's do this so it provides a snapshot and an accurate look. But let's start from the beginning. Lori, you did not start your career at the DIFC, and for those who are not geeks on the interesting structures of data protection authorities around the world, what is the DIFC, and how did you end up playing the leading role at the office?
Okay, thanks, Jules. Yeah, that's all really good stuff to lead into this, and we'll get to some of the comments on some of the countries that you raised in particular. But DIFC is Dubai International Financial Center. It started as a purely financial center for commercial banks and financial services in 2004. There was a federal law passed in the UAE that said basically there's an opportunity to carve out these free zone jurisdictions, financial free zones, that have absolutely no remit from commercial or civil law at the federal level. So that law when it was enacted, gave the ability to the Emirates to create their own free zones. Dubai was the first. In 2004, it created the Dubai International Financial Center. Um, and so we are our own little kind of virtual island, if you will. In the middle of Dubai, we have our own laws, we have our own courts. We have a commissioner of data protection. I'm the director of data protection. The commissioner is Jacques Visser. He and I work together to do things like the EDMRI and set policy around how we're going to deal with data protection, supervision, and enforcement in this jurisdiction. We're also, for example, being evaluated by the UK for adequacy recognition. We do our own adequacy recognition submissions as well. And yeah, we spent a lot of time on international transfers in particular. So that's a bit on the DIFC, a bit on myself. No, I didn't start in Dubai. I've been here about 6.5 years now, but I was in London for about 10 years before that, working for BT, working for Dun& Bradstreet as a European DPO, even though my accent doesn't quite place me as a European. I am American. I moved over from the United States to London in about 2006. I know at 15, how could you possibly already have a law degree and all that? But no, I'm. But in any case, yeah. So I moved over, and that's where my career in data protection started, basically about 17 years ago.
Yeah, and although less common in the U.S. and some countries, not at all uncommon in the Mid East and a number of regions around the world, where to attract top quality experts to the civil service, recruiting will be quite global, and one ends up meeting a real interesting, set of the best and brightest sometimes from around the world who are filling senior levels. So quite fabulous that the team there has you on board. So why did you do this? And did you, one of the things I love about our field is that it can seem very cut and dry, contracts and standard clauses. Gabriela mentioned probably the comparison we did recently of the not so standard contracts that seem to be very different or maybe inconveniently different across regions. But there's actually a lot of drama under this. There's human rights, there's trade, there's politics. What and why did you take on this project of, and how did it work? And give us a little bit of a flavor. I was nervous to even ask you, but it sounds like you're bold enough to go there. Well, are there countries that are red? And because, you look around the world, you ask any company, who's on your red list? Oh, nobody wants to talk about poking an eye and so on and so forth. Was it considered impolitic? Did you get heat from, should we not even look at the actual list?
Well, I'm happy to share the list. I will be virtually ducking maybe every now and then, but look, it's not a political thing. It's pitched as guidance from us to our companies. It is still a relatively young jurisdiction. Data protection in the region is developing. It's not new. I wouldn't say it's definitely new by any stretch. I mean, there's always been data protection principles, cybersecurity, what have you, whether we knew it or not. The DIFC data protection law has been around since 2004. So in any case, it's still something that is novel in certain ways to certain companies. So, to help our companies along in the DIFC, to protect them a little bit, we felt, after Schrems 2 in 2020, I was speaking with a few of the other experts around in the DIFC. We're a much, much bigger group now. It was quite a handful just a few years ago. And we kind of said, okay, well, then what should we do? What are we supposed to do with respect to international transfers? Reading the text of the outcome of that case, we thought, okay, let's we've got to do something. So we took it upon ourselves. I went ahead and put together basically just how we gather the raw data. It's a list of about 35 to 40 questions broken down into kind of themes areas, let's say. And that was what we tried to do to depoliticize it, let's say. It's just, if you look at one of the reports, you have thematics around laws and regulations. Okay, so what data protection laws are there? Also, what cybersecurity laws are there? What other laws exist in that jurisdiction that might have data protection principles in them? Where do you get your sort of data protectionness from? And who are the regulators? That's the next bit about it. How is it enforced? Who are the regulators? Are there other regulators, again, that carry out privacy like supervision? And then we get into the stuff that you mentioned, Jules, like human rights things, so what is the privacy culture? That was one of the things that the people that we had doing the research for us, because we wanted to sort of stay out of it and be quite independent from it. They would come back and say, how do we answer that question? How do we answer privacy culture in a jurisdiction? Well, and again, it's basically around, well, what are your clients like? What are the companies that are coming to you like? Are they looking to fully and robustly comply with the law, or are they looking to do the bare minimum? Do they even understand it? What are the people on the street like? What do they know about their rights? What kinds of complaints come in? You can look at the regulators and what kind of things they are doing to enforce. So it asks a number of questions. And just like the Transparency International Index, which is what we're trying to create, was an index, we're kind of looking at privacy corruption, not just business corruption, let's say. So where there's a gap with respect to not just the jurisdiction, and this is the kind of twist, this is the kicker. It's not just an adequacy assessment. It's not even a more sort of holistic adequacy assessment. What it is what then is the propensity for compliance in that jurisdiction? Those kinds of things that we're talking about. Who are the importers that you're sending data to in these jurisdictions, and what are they going to do with the data? What's the likelihood of them, based on all these factors, actually complying with the contracts that you sign with them, with the laws and regulations in that jurisdiction? And the ethical part is in a variety of ways. One of the first things that comes to mind is, well, if for example, having done your review of our index and then maybe some additional due diligence that we recommend, if you kind of look at your importer and say, well, they're not exactly great, or we have a lot of no's to our questions about whether they have a privacy policy, whether they have a compliance program, what have you, should you actually share that data with them? What can you do alternatively to find maybe a different importer, to improve the standards of that importer? So we look beyond the jurisdiction and we gave guidance around what we thought would most likely happen if you shared data with an importer in a specific place. That's the other sort of side of it that's not necessarily very political. So we haven't taken a lot of heat from it. We might after this. And I'm happy again to share what it looks like if you like, Jules. But that was the idea behind it, was to get to that due diligence side of things that was lacking.
Yeah,
So in 2020 we put it together, and that's how we came up with it.
let's definitely take a quick peek at it.
Okay.
I'll welcome some of our friends in the global data protection world that I see joining in. Hey, all, too many of you to mention, but Tara Taubman flags, of course, well, whatever assessment's done, nothing can remedy the lack of a judicial remedy for EU data subjects. What I think is interesting, so of course, important, interesting point, but what I think you got to here, and one of the important points is effective, actual, practical on the books, or actually exercisable, because of course you got to have the law on the books, and that's the important thing that the I think ECJ established. But I think what we're going to see around the world, because people want to have a first-class law, want to have adequacy, is laws on the books in jurisdictions where it's a joke to think that someone is going to go to court and get. So I've been trying to find, for instance, examples of people effectively exercising in, well, many countries in Europe. Now, I get there are a couple of big important cases, and indeed, at the end of the day, the court is, striking down laws and statutes. But I'll eat my hat if I can effectively, in a range of countries in the world, let alone maybe some European jurisdictions, effectively get an answer about whether the surveillance authorities have looked at my data specifically with the kinds of answers that people are demanding in some of these cases. Now, I get law in the book matters, and it's a little bit of an impolitic question to say, oh yeah, does that actually work? But I think that's where you went. Maybe so.
That
I
is,
don't know how should we take a look a little bit at
sure.
that?
Here, let me should I pull it up? I can
Let's
go
do
ahead
it.
and
Let's do it.
okay,
Let's
great.
take a peek. And
So
again, I think
let's see.
the reason why this isn't the most politically scary thing is at the end of the day, the answer isn't you can't do it. You might need far more significant a technical structure to add more protections. You might jump a little higher to work with a much more responsible importer. So how did you handle the process? And
yeah, it's an interesting one. Yeah, it's exactly that. I mean, it's again focusing on the importers, right? All the other bits and pieces around it are assessed, including judicial redress, and I can show you that as well. But the idea is, if you're sharing data with an importer that you shouldn't share data with, I mean, that one of the fundamental questions about the Schrems cases, like why are you sending data to an importer that might not actually be caring for your data the way you might expect it to be cared for? That's no comment on any of the companies that were involved. It's just to say that ethically, if you've done your assessment and you've done your due diligence based on our guidance, would you have shared that data? And if you have to share that data because practically, your senior management says to, they're the cheapest, they're the whatever, most effective, well, then do something about getting it tidied up, let's say. So this is what it looks like. We also left in the column about which countries have adequacy, which countries don't. If it says DIFC, it's because we've recognized them. But if you look, for example, let's just go to, and I am randomly picking something here. If you go to, let's say, the Philippines, which we've said for importers, again, you see data import risk rating. This is how we broke it down, and hopefully you can see this well enough. Maybe I'll go back a little bit so you can see the whole thing. So again, this is our thematic risk rating. You see this first. So you see the groupings: laws and regulations, regulator supervision and enforcement. And then all of our rationales are there as well. And that's effectively the methodology for making this assessment. And it's all just goes through a tool, gets assessed. We, of course, review the assessment and sort of see if there's been any weird anomalies or anything that we need to tweak. And then fairly, let's say. And then this is what gets published, right? So accountability and transparency, individual rights and redress. So is, for example, redress available? What mechanisms are available for redress? How do they work? Like you're saying, are they effective? And you could go to places where, and one of the arguments that I say all the time about effective redress in other jurisdictions, for example, even in Europe, is, well, get to the CJEU first, right? How many courts of first instance actually do take in that sort of case in the first place, let's say, or a complaint or what have you? That's what we're looking at here. What's the likelihood of that even happening? You have to get there before you get redress, right? So
this is the most useful resource for others who are here, by the way, who are maybe beyond sort of the international kind of relations and trade pieces. If you're an organization, there are people who've paid hundreds and hundreds of thousands of dollars to their outside counsel, to do this. So great. We love our lawyer friends being happy and wealthy and smart. But if you are not, in possession of a retainer with a top firm with international global expertise, this is a wonderful place, frankly, for you to start. So really useful tool for, businesses of every size. Gabriela, let me bring you in for a moment here. Your thoughts, reaction, what can you add to this?
I was wondering, Laurie, if you're also looking at the national security practices, so beyond law enforcement access to data as one point. And then I sneakily saw there on the first slide, or not slide, the first page with the table, that California was assessed separately in the US.
It was, yeah.
I wonder, how did you go about that, and who else in the US is assessed, or maybe the US as a whole, and what did you find there?
Yeah, we got a lot of states now.
Yeah. So, well, this is what we've done so far. I should say we're adding to this in terms of. So I've added the U.S. here. California is over here, which is kind of interesting. But US, if you want to look at US as a whole, we went ahead and did it this way. So we've got 4 states assessed so far. We're adding more within the next few months because, there's just been a whole flood of them. But again, we look at this broken down, in terms of laws and regulations, regulators and supervision, and so on and so forth. So and we've also added the Transparency International corruption rating, and I'll explain why. The idea being that if there's a propensity for corruption in jurisdiction for noncompliance with laws generally, and for unethical behavior, then that probably bleeds into privacy, human rights, and so on as well. So we include that as well. In any case, then you see, for example, here's our overall assessment. And at the end, we've included our state assessment. So you can go and see what we've said for these particular states. We added California separately because that's our most complete one. And, has just recently changed as well. And then I want to also mention what we do here.
Most complete.
Oh, sorry, go ahead.
No, I was about to say this is what the US would say. California is our most complete one.
Yeah, exactly. So, and then what we've done as well is we've said basically, if you look at these ratings, so low, we're not really concerned about the importing entity complying with existing laws, all the way up to high, there's a significant degree of concerns about importing entity complying with existing laws, right? So, and so on, not just laws. And then if you look, so this one's medium. For a medium, we've basically said every time that you don't have to complete what we call the EDMRI plus in order to understand potential risks and so on, but it's probably a good idea to go ahead and do so. The EDMRI plus quickly is this due diligence risk assessment. It's basically a number of questions that if you go through, it's asking about your company, it's asking about your importer, what are they doing with respect to compliance with various parts of our law, with their own laws, with, just having DPIAs in place, with having compliance programs in place? What are they doing with respect to explanations of individual rights and so on? And then basically, I could go through it, but we've broken it down that if you get a number of no's or don't knows, that says to us on this due diligence assessment that, well, you probably need to go back to your importer and answer a lot of those questions or get answers to those questions, like, well, when will you have a privacy policy? Why don't you have one on your website? And it kind of raises the bar at the same time, I guess, in a way, which was an unintended, natural sort of consequence, I guess. But the idea was, again, to go back to the guidance, was to be able to say, we're giving you guidance here. We don't have, again, a political stake in this necessarily. We just want to be honest about how practically you need to look at the importers in a certain jurisdiction and maybe the precautions that you should take. I should also preface this by saying this is just our view of the world. This is the DIFC guidance based on our own criteria. It is fully open to comment. We have feedback in the survey available. We still are taking feedback anytime. If anybody has suggestions, anything that you think is just absolute rubbish. I mean, we're not saying that we're right. We're just saying this is what we think our companies will benefit from.
And Lori, just in terms of the process, you didn't do this yourself sitting at your desk. There was comment, there was feedback. You had experts helping. What's the expertise behind this?
So basically, well, yeah. So I put together. Let's see. Do I have it in here? I had a place where we have the actual tool itself.
And by the way, for those asking,
the raw data. Sorry?
You don't need the slides because this is public on the DIFC site. We will post in the comments, and you can. Oh, there it is.
It's on our guidance website. Yeah.
There you go. So it looks like that. You can choose the right set of links. We'll post it in the comments, and you can access it directly. But you had you had some experts working with you. You had
yeah. So what we did basically, we had so I put together my questionnaire, spoke with a law firm. We used one law firm here in Dubai. We spoke with another law firm in India, and we basically took those bits of research, kind of combined them into um, a rating tool, sort of basically a calculator that we came up with based on our methodology and weighting scale. And then we got our results. We pretty much just went from there with putting it into guidance format, turning it into a narrative, and sort of giving the information that we thought was most useful. We didn't really snip a lot, though. I mean, there were some things that we thought, we don't want to get involved in making any political statements. Some of the feedback that we got from the experts that we did use, some of the answers. And if you see what I provided on that screen, that column that basically tells you the answers, that's almost raw data. We didn't really do a lot of snipping to that, because we wanted to just see exactly what those experts came back with. So yeah, that was it. Really, it was just a matter of getting the feedback, getting the information from the two law firms, putting it through our methodology calculator, let's say, and coming up with our narratives. It is PDF based. It's not very fancy. I'm really hoping that someday we make it a more automated thing, and maybe even that, we're working on a project actually that involves a platform built from AI that would help to kind of learn about this tool and add information as and when it becomes available from outside sources, from online sources, what have you.
Let's touch two other things, and then we'll try to bring in a couple of the
Sure.
questions we are watching. So do feel free to post, and we'll try to turn to them. Gabriela, there was a lot of activity, was it a week or two ago or last week, around the global CBPRs. You want to raise that with Laurie? So open up the question, and we'll hand over to her for a little bit of what's the latest?
Oh, yeah, absolutely. So just to brief our friends here on LinkedIn, there was a global CBPR forum organized in London a couple of weeks back. And apparently it was a very well-attended event, and it also ended up with the first non-APAC country that officially signed up to be part of this framework. And that's the UK, to be clear. Laurie, you are there, right?
Yep.
You're following the process. We'd want to understand a bit more what's going on. What can you share from the forum in the UK? And we know that last year there were a couple more, one in Hawaii, one in Seoul. What are you learning from this, and what can you share with us?
Yes. Yeah. So back in 2022, just a bit of context as to why we're even involved is we recognized Singapore and South Korea for adequacy. And in our adequacy decisions, we also included the CBPRs and PRP in Singapore as an adequate mechanism, effectively, and the CBPRs in South Korea. And that kicked off a conversation with the Global Forum organizers. They had been working on it, presumably, because it couldn't have just come up between February 2022 and April 2022. So, they got in touch. Bermuda had done something similar quite recently before that. So the commissioner's office in Bermuda has been involved as well, because, there's this recognition that by some that the CBPRs could be a really useful alternative mechanism for a lot of reasons. Maybe not accepted everywhere, but certainly, it's a mechanism. It's an additional way of doing things that we thought we should recognize. So yeah, I went to Hawaii, I went to Seoul, I went to London, and it's just gotten bigger each time. We're talking about things that will help other jurisdictions that are attending to understand what the CBPRs are about, why it would be useful to have a global set of CBPRs and have a global framework. And last year in London, I remember in Hawaii, there were about, I don't know, 8 to 10 regulators there from different countries. I think this year in London, there were easily about 5 or 8 more. So there's definitely interest. It was a much, much bigger group this year. We were making a lot of progress in terms of the governance of the forum, who the chair will be, what kinds of enforcement uh, documentation there would be with respect to sort of cooperative enforcement. I don't think I'm giving too much away because this is all on the website, and should be sort of talked about publicly. I think because again, we're all looking for ways to deal with data transfers, and this could be one. So if you're interested at all, if you're on the phone in becoming an accountability agent or in certifying, there's plenty of information on the web that you could look into that. And then we're looking into joining as well as members. So hopefully we'll be submitting our application soon.
There's been an, I think, unfair rap, and we don't have as deep a stake in this. We haven't been as involved. There's a lot of issues, and we try to spend our time on the ones where we are truly needed or where we've got the particular expertise, and we are interested in follow and support the process. And obviously think that somebody asked, is there can a global country use one contract around the world? And the reality is, what's really happening. And let me just tell you, as somebody who spent almost a decade as a chief privacy officer, you hand these things out, and if your partner is smaller than you, they sign it, it goes in a drawer, and it's never seen again. And at some set of companies, there's a lot of drafting and redrafting and negotiating, and nobody's ever sure that actually the regulator would view the process and the alignment and what's needed in those particular documents and how you're positioning yourself in the same way that the 4 law firms around the table do. So the biggest firms in the world are spending a fortune. Everyone else is like, what? How is it possible that my university actually needs a squad of 100 lawyers signing multiple contracts because our students, because we regularly send data at large scale, again, unless people are working with some derogation. So to respond to the question, no, today you are cooked. But the misperception that I think is fair is that there's this argument out there that there's the European model and the European adequacy structure. And then this is an effort by everyone else, US, APAC, whatever it is, to have sort of a different, coalition or a different model. And I think that's somewhat unfair. The rest of the world does not have anything like the Schrems judgment. The rest of the world, leaving Europe aside, is transferring data back and forth, US to Dubai, Dubai to Israel, regions all over the place. And there needs to be a mechanism that is, separate from whatever adequacy structure, whether or not there's a future thing where that all also then maps to Europe, hope there is one day, but the rest of the world does need to function with international data flows as well. And it's not really but it gets played like that sometimes. And I think that's not
Jules,
really fair.
There were European regulators there in London.
Oh, there you go.
There were guys from the EU. I mean, again, and I can't put too fine a point on it. It's not an us and them at all. It's this is another option. And if it's one that works, if it's one that requires certification of a company, even better. I mean, a company can actually say, yeah, I'm certified. This is what I do. Even think BCRs, what have you. And it's, why not? I mean, it can't hurt, right? There's nothing about it that can hurt necessarily. And it doesn't necessarily mean fragmentation either. It just means this company is, has got their game on with respect to data protection, and you can trust them.
Let's bring in one more topic.
Sure.
And I'm sorry, Ashley's got a great question. It's super complicated. I don't know that we're going to be able to get into some of that. And the reservations about the CBPR system in general. Again, an entire show to sort of walk through what people like, what people think is working, what people think needs to be improved. There is a law that has been passed in the global data protection community, and that's thou shalt not have a panel without mentioning generative AI, LLMs. If you can mention specifically ChatGPT, you get the trifecta. Can you give us a quick what's going on? AI regulation isn't new to you in the region. Is the drama that we're seeing with companies around the world and governments around the world all, oh, this is a game changer, this is going to be a big thing, oh, we have to deal with the obvious problems? Is there as much sort of new buzz as we're seeing in certainly US and Europe around LLMs? And how have you been looking at this issue?
Yeah, that's a good question. I mean, this region, especially the UAE and Dubai in particular, are building it. I mean, there's so much tech here it's not even funny. And so the thing that we've been doing generally is watching. We're outside the fray. We're kind of safely outside of that kind of hole. What's really going on in the hotbeds, let's say. But that gives us a bit of comfort as well to be able to say, well, let's step back and think about this. How do we want to do it? So we know that AI, generative models, what have you, are being built in this region. There's lots of tech going on here, and it's really, really interesting stuff, really, really advanced stuff. What we did here in DIFC, and we have a consultation out on it now, is said, okay, all we can really do is, if we're going to try and regulate this thing, is look at it from the perspective of our data protection law. That's the only thing we have the option to do, if we're going to write regulations, is come from that perspective. So that's what we've done, and it's a page and a half of regulations, because that's what fits for us. That's what fits for our jurisdiction. But we looked at, for example, what initial guardrails would we put in place to protect personal data and build data protection by design into these systems. And that's what we've put out for consultation. And I've thought of things literally within days of posting the consultation that I want to add already. And I'm sure there's really great suggestions out there. Please, by all means, get your comments in. Again, we don't necessarily think we're right. We think that we're, taking a good first step, and we're all in this together. So please get your comments in on our consultation. We'd love to hear from you. But that's it. It's just looking at personal data through these systems. What would we suggest is done to safeguard it from vis-a-vis our data protection law? Just really quickly, one of the things that we insisted on building into the data protection law, it's kind of like that maxim about, there was a railroad built over the Alps before there was a train that could ride on it. We kind of looked a few years ago at saying, well, how do we solve for certain things like data subjects rights when technology that's being built it doesn't permit it? It's indelible. You can't necessarily alter, you can't remove, you can't do a whole lot once something's been put into a decentralized sort of ledger kind of system or what have you. So we put in a requirement to provide extra assessment, to provide notices, and that's what we've enacted through the regulations. It's what we've built out into detail as one of that pieces of the regulation is from that part of the law. So now we're looking at actually taking it forward, and then we'll hopefully do some sort of use case testing, sandbox sort of environment maybe. We hear that word thrown around a lot, and we don't really know what comes out of them sometimes. But we're going to at least test it with anybody that is willing to jump in, and any use cases at all. So, and then we'll see what we add to the regs. We'll see what we add to guidance, and that's kind of our model, is to just keep it living. Like I said, it's a living sort of growing thing. There's nothing that you can do to just sort of put a line in the sand and say this is what our regs are. They're going to have to change because the technology will too.
Gabriela, final thoughts.
Final thoughts. I really, really love this approach, Lori, on thinking about how you can enhance data protection law to deal with this new generation of technology. And I will just flag that 70 years ago, when people were thinking about data protection law and what provisions to put in place and all of that, they were thinking of an almighty computer. They were just seeing computers being built and this huge data centers and new capabilities of automation. They did not have online, they did not have internet. They realized that this is a technological moment that needs to be met, came up with some safeguards, and they were actually saying, we know there will be iterations and generations of data protection law to follow. So I think, this might be the case for thinking of a new generation, the next generation of data protection, as we're seeing the next generation of computing. Yep. So I'll
totally agree.
My final thought is, look, I see a lot of folks in the data protection community looking at the LLM issues, and look, there are plenty of problems, but it's as if we are ignoring many years of data protection case law on many of the issues. So people are saying, it came from the public data sets. That can't be possible. How can anybody have given? Excuse me, this isn't the first time. Well, search engines Well, a whole set of different research tools. In fact, much of the data used by these LLMs has not actually even been recently crawled by them. There's a data set called the Common Crawl. It's out there there for free. It's hosted on AWS. It's used by a vast number of researchers and commercial entities. And guess what? Lots of folks currently crawling Wikipedia and Reddit. Now, of course, in some jurisdictions, just because it's public doesn't mean it's a free for all, right? You do need to have a legal basis in Europe. We have lots of case law. We have Costea for the authority to spider these sorts of things. And of course, data protection law is applicable, but people are coming to it as if something was invented and there were no lawyers whatsoever. Now, probably stuff they didn't do right. We see many regulators opening up, inquiries. Assessments are going to be disagreed with, but, it's easy to look at some of these new things and say, oh, those people didn't even know about data protection law. There are blue chip law firms. Now, again, we can disagree and think that they're not smart enough and so forth. But some of the best and highest paid and smartest data protection lawyers are working on this stuff. Now, turns out that when we look at it with fresh eyes, we might say, oh, actually, maybe people have thought legitimate interest works for this, or maybe nobody ever thought you would block kids from, such and such a thing. And guess what? Now that we're looking at it, we're going to disagree and, make you change those things or issue fines and so forth. But stop looking at everything as if, we are the only geniuses and everyone else on the other side is just like silly and stupid. They're not. You don't build this stuff and be dumb. Now, you might roll these things out without having all the answers and take some real risks and be slapped on the risk. But, in lots of the conversations, we've been having with a whole range of people before the ChatGPT, this didn't, we all saw this now because the consumer product was rolled out, but people have been working on this for years and people have been working on the AI issues for years. These aren't super novel. It comes with some complexities because of a lot of the non-data protection issues. But when it comes to the data protection issues, we have a framework. Gabriela has been making the argument for years, as I think, many, that data protection is the first cut of how to regulate this, already regulates this. Our global team did a report looking at all the cases of automated decision-making across Europe. There's a lot of case law already on the books. So let's bring that knowledge and assess it, and we can debate where there are different views about a legal basis, different views about public data, different views about children. But that's my final thought for today. It is late in the day in Dubai, so we thank Laurie Baker and the DFC team for joining us. Thanks to those who joined us in the chat. Gabriela, thank you for joining. We will be back next Friday. We'll be back next Friday, but in 2 Fridays, we have a very special guest, a famed journalist who has a new book, a famous tech reporter who has worked at the New York Times, the Washington Post, has a very big and bold presence on social media. We will promote that shortly, but that'll be Laurie's clearly one of our celebrity speakers, but this will be one of our, say, perhaps more even popular culture celebrities. Her first name is Taylor. Okay, that's the clue. Have a great weekend, everybody. Thank you for joining us. We'll post the link to the resources in the chat. Laurie, if there's anything you want to post, folks who are following along, please take advantage of looking at all the valuable stuff on the DFC site.
Will do.
Happy weekend.
Thanks, guys. Have a good weekend.